Hello guys, I'm back again, Dr. Sweni, but this time around with another thing, that is the chilling silent effect defamation in Kenya and the newsroom. How defamation affects journalism and how it affects the freedom of the press and even responsible communication. Join me for more. In Kenya, the law of defamation represents a delicate balancing act between two fundamental constitutional rights. These are the right to freedom of expression in Article 33 of the 2010 Kenyan Constitution and the right to human dignity and reputation in Article 28. That for journalists and even media practitioners, navigating this legal landscape is a daily necessity, as a single error can lead to crippling lawsuits, while too much caution can result in chill reporting that fails the public interest. Defamation is a civil wrong or tort that occurs when a person publishes a false statement that tends to lower the reputation of another in the estimation of right-thinking members of society. Under the Defamation Act, Cap 36, for a claim to succeed, the plaintiff must prove three things. These are: the statement was defamatory, the statement referred to the plaintiff, and the statement was published. There are two types of defamation. These are libel and slander. Under libel is defamation in a permanent form, such as written articles in newspapers, magazines, posts on social media platforms, books, or even broadcasted television and radio segments. The law often presumes damage has occurred without the victim having to prove specific financial loss because libel is permanent. For example, a newspaper headline falsely claiming a prominent business person is involved in a gold scamming syndicate. Slander is defamation in a transit form, usually spoken words or gestures. Unlike libel, the plaintiff usually must prove special damage, for example, actual loss of money or business, unless the slander falls under specific exceptions such as accusing someone of a crime or unfitness in their profession. For example, a politician making an off-the-cuff false remark during a live rally accusing a rival of being a convicted thief. High-profile defamation suits, often seeking millions of shillings in damages, can intimidate media houses when journalists fear that reporting on corruption or powerful individuals will lead to expensive, decade-long court battles. They may kill sensitive stories. This chilling effect weakens the watchdog role of the press. In Kenya, courts have historically awarded significant damages in defamation cases for small, independent media outlets or freelance investigative bloggers. A single lost case can lead to bankruptcy. This financial risk often dictates which stories get told and which are ignored. The media's defense freedom of press is not absolute. It comes with the duty of care to protect themselves. Journalists must adhere to the principles of responsible communication. If a journalist is sued, they can rely on several legal defenses. If the statement is true, it is not defamatory. However, the burden of proof lies with the journalist to prove evidence for every material allegation. Defamation law in Kenya is essential for protecting individuals from character assassination, but it must be applied carefully to ensure it does not become a tool for censorship. For a healthy democracy, journalists must practice responsible communication, verifying facts, seeking right of reply, and acting without malice, while the judiciary must ensure that damage awards are proportionate to prevent the accidental strangling of the free press.